Okay, welcome to the Aldav Law Studios coming out of San Diego, California. Welcome, Keith.
Welcome, Stuart.
Are you excited to be here?
I am. Yeah, I'm really looking forward to this one.
We have people from our international audience, just blows me away. People from all over the place, and then, of course, all over these great United States. And Keith, I just have one question for you right up front today.
Oh, boy.
All right. Are you too big to fail at this point?
I'm definitely not. Yeah. And if I was, I wouldn't go around saying it. That's for sure.
Well, how do you deal with your enemies?
Yeah. I try very hard not to drink their blood.
Okay. Well,
I'm not saying I don't, but I try not to.
So that's a good point. So obviously we're here on a response from the Baldoni crew.
Yeah.
And this is to Ryan Reynolds' motion to dismiss their lawsuit against him for defamation and some other claims.
Yeah.
And you really took some time today to dig through this.
Well, we both did. And it was interesting reading. And I think that, I think we have a lot to talk about on this one.
Well, why don't we jump right into it? And please, the jury pool, if you want to throw some questions at us today, we'll be happy to. We got producer Eric here who'll be watching like an eagle over there.
Yep.
And any good questions, at least in his opinion, they're good questions. So in other words, Eric, if you don't put questions up today, it's because you didn't think they were good questions.
I didn't say that. Hey, right off the bat, guys, do you two ever argue or get mad at each other?
Oh, boy.
Yeah, no, never. 18 years, we've never one time argued.
Keith is wrong a lot.
Yeah. So I've been told.
Thanks for the question. That was Betty Garcia.
Betty, thank you for the question. Keith, I think we get along really well.
Yeah. I think, we argue a lot on our cases, but that's in order to make them better and make our arguments better. And every now and again, we get on each other's nerves, but by and large.
And you're usually wrong.
Typically.
When that happens.
That is what I'm told. And as soon as I admit that, argument over. So.
Okay. All right. So let's go ahead and jump right in. We have the opposition here. This is Justin Baldoni's opposition. Why don't you take us through just your initial thoughts here of the introduction page?
Well, they start with this bombastic line that I've realized that I'm too big to fail at this point, so I just crush my enemies and drink their blood. I guess something Ryan Reynolds said, I'm assuming as a joke. It has no, from a legal perspective, it has no legal relevance in this opposition. It's not in the pleadings, I don't believe. I don't think that it's here for any legal reason. It's here for public consumption and for the public PR battle, I think.
Okay. Well, I'm curious for the jury pool. What do you think? Starting this brief off, were you impressed with this quote? And, when I saw it, my initial reaction was, Ryan Reynolds said this being goofy to somebody, but I don't know. I did see there's a footnote there. And by the way, core random opinion, Eric, I see she's here. And by the way, I just want to shout out to you. I really enjoy watching your videos. You're doing a great job out there. Keep the good work up. And is there a question for us, Eric?
No, she was just thanking us.
Oh, well.
Oh, wow. Thank you so much.
It's very kind of you. Appreciate that. All right. So Keith, today we're going to bounce around a little bit and we're going to really identify the issues that came up in this opposition and the issues that were addressed by Team Baldoni. And so one of the first issues that comes up is, is the complaint that Team Baldoni drafted, is it legally sufficient?
Right.
And can you just from a 40,000 foot standpoint, what is this issue of the complaint being or not being legally sufficient?
So the argument on Ryan Reynolds' motion to dismiss is that the defamation claim against him was not legally sufficient because it didn't specify enough details. So it didn't say the what, the where, the why, the when. And so you have to say, what was said, when it was said, to who it was said, and who it affected, whose reputation did it really affect. And so that was the argument on Ryan Reynolds' side, is that you didn't say those specific things. And so just as a form of pleading, you didn't plead it properly. And so that was their argument.
And the requirement here would be for Team Baldoni or anybody filing a complaint in federal court to put an adequate amount of facts in the complaint. Is that how that works?
Yeah. So I can't sue you for defamation and file a complaint that says Stuart said something bad about me sometime. That's not going to be enough. And so just from a pleading standpoint, you could file a motion to dismiss, the court would grant it, but give me leave to amend. Then I'd have to come back and say, okay, on such and such a date or around this time period, Stuart told a room full of people that I was an S predator. And, so you have to have those kind of specifics is the point.
Okay. So the accusation or the argument has been made in Ryan Reynolds 12B6 that the complaint that Justin and crew filed against him is not legally sufficient Tell us about your analysis and what you saw in this opposition.
So I was looking on page 6. And really, it starts off at the very top there. The first paragraph, you have some highlights in, saying that the federal rules require that each pleading be specific enough to afford the defendant sufficient notice of the communications complained of to enable him to defend himself. So think about that. You don't have to be over specific. You have to be specific enough so that the defendant knows what the lawsuit's about. And then the part that you have underlined, why did you underline that, by the way?
So it says Reynolds must have confused the rules of pleading with the rules of evidence. And Keith, you and I run into this all the time. We file, people file demurs against us. We file petitions, which are complaints essentially in federal court. And when we file those, people demur against them, which is like a motion to dismiss. And they say that we have not proven in our filing, our initial complaint filing, we haven't proven our case. And we see this all the time. So why is it that you think that this is being pointed out here that, hey, and it's done in a cheeky way. I don't think it's meant as a compliment or even to give them an excuse. It's to point out you don't know what you're talking about. Yeah,
I love the way it's worded too. Reynolds must have confused the rules of pleading with the rules of evidence. It's not he did confuse it. It's like he must have. Because the rules of pleading are very different from what you have to do come time of trial.
Let me ask you, if you're pleading a case initially at the very beginning and you don't have all the facts, obviously, and the person you're suing, they have more facts because they know they were there, they did the bad act, if in fact they did it. Is it more lax? Is the court more lax on the rules for pleading than they are on actually bringing evidence in that you're going to put in front of a jury?
Yeah, for sure. And nobody has had a chance to do discovery yet. And you can actually see at the end of that paragraph where it specifically says that less particularity is required in the allegations of the complaint where the adverse party has a knowledge of the facts superior to the party pleading them. So I wasn't in the room with Ryan Reynolds when he said these things, but I heard about it. So therefore, I can plead some facts that are specific, but I'm not going to be able to tell you every specificity because I wasn't there. But I will be able to tell you that come time of trial because I'm going to be taking a whole bunch of depositions and I'm going to find out.
So you're not required to prove and win your case in the complaint that you file at the onset of a litigated matter. Is that a fair statement?
Yeah, that's a fair statement.
And so you just have to put the defendant on notice that, hey, I'm suing you for X, and here are some of the facts that I either know or I think are true, and here they are. I'm putting you on notice. Now you need to respond to this.
Yeah, and that's why they call these allegations in the complaint, because we don't know if they're supported by evidence yet or not. We believe them to be true, but at this point of the game, remember, we're only on a 12B6 motion to dismiss. We're just looking at if we take these allegations that you have in here, and even if we assume them as true, is it enough to at least state a legal claim? They're trying to say it's not. And then now Baldoni's coming back and saying, no. We told you enough specificity. You know what we're talking about.
So just looking at this issue, the issue of whether the complaint, Justin Baldoni's complaint, is legally sufficient, what are your thoughts? Is it legally sufficient?
Oh, I think it is. I mean, from my point of view, I think it's pretty clear what he's suing about. And the next paragraph down, we'll kind of look at what those allegations are. But I don't think there's any doubt as to what the defamation, the claim defamation statement is. And you'll see here that he specifically alleged that at least twice Reynolds stated to WME executives that Baldoni is a S predator and that by implication WME was in business with an S predator. So, I mean, that's pretty strong. I mean, first of all, that's a strong allegation. I don't think a defendant's looking at going, gosh, I don't know what I'm being sued for. No, you know what you're being sued for. Now, you could dispute whether or not you said that. You could say, I never said that, whatever. But I don't think there's any doubt what you're being sued for. What are your thoughts on that?
No, I think that it's very clear. And here they're pointing actually to the first amended complaint. And by the way, what does FAC stand for?
First amended complaint.
It's not the filed amended complaint. It's the first amended
Although
complaint.
It has been filed.
It has been filed. So that's the first amended complaint. And an SAC would be?
Second amended complaint.
Okay,
yes.
So this is how this works and how we do this. But see, so what Baldoni's saying is look back at the complaint I filed, look at paragraph 8, look at paragraph 162, and you're going to see that the S predator stuff is in there. And that's what we're alleging in our claim against Ryan Reynolds.
Yeah. And so they're taking it right out of their allegations, that's the standard. You only look at the four corners of the complaint and then the exhibit. And see about midway down there, it says, On the call, so FAC Exhibit A at 99, on the call, Reynolds referred to Baldoni as a deranged predator and warned Greenberg that Baldoni should not attend the film's premiere the next month because no one wants him here. So again, I don't think any defendant seeing that is like, I don't know what I'm being sued for. No, it's pretty clear. I think it's right there.
I think it's important. We've pointed this out before, but it's important for people to understand that at this phase of the litigation, where there's a 12B6 being filed here, everything that Justin Baldoni says in his complaint has to be seen as being true. Okay. Now, judges do have some discretion here, but the idea behind it is the four corners of his complaint are what we're looking at. And we're just going to assume that the facts he puts in there are truthful because we're just measuring his complaint to see, does it state legally sufficient claims to move forward with a lawsuit? So the only way to measure that at this phase of the litigation, because discovery hasn't been taken place, depositions haven't taken place, third-party subpoenas haven't gone out.
Yeah.
We're going to accept these statements as true, and then we're going to say, if these are true, have they stated legally sufficient claims to continue this case forward?
Yeah, very technical. It's a very technical exercise. But that's why they were saying before that Ryan Reynolds must have confused the standard for pleading for the standard of evidence. Because you do kind of wonder, maybe they did confuse. Well, they didn't. His lawyers didn't intentionally confuse it. I mean, they're obviously doing the best argument that they can. But I don't think that's going to work. And then let's go down to page 7, because there is another aspect to this.
Hey guys, say hi to Billy Bush. He's here. He says he loves the show.
Oh, nice.
Oh, wow. Is that the real Billy Bush?
I think so.
Wow. Hey, I reached out to you. I wanted to be on your show. What's going on? Get back to me.
Appreciate that, Billy Bush. So let's look at, here's the interesting part. So the other aspect of this is Ryan Reynolds said, well, wait a minute. I made these statements about Baldoni, but not the other Wayfarer parties.
Which paragraph you got here, Keith?
The first full paragraph that starts with as to the other Wayfarer parties.
All right.
So this is the other aspect of saying that this is not legally sufficient. So they're saying, Ryan Reynolds' attorney was saying, well, I didn't say anything bad about the other Wayfarer parties. Now they're coming in and arguing, well, wait a minute. The First Amendment complaint alleges that Reynolds worked in concert with Lively and Sloan parties to publicly and falsely smear them. So he was trying to smear all of the Wayfarer parties. And so that's what they're saying. Look, that's what we alleged in our First Amendment complaint, that these statements and these actions that Reynolds took was smearing everybody, not just Baldoni. And so that's how they argue against this idea that he didn't say anything. Let's see. I think it's the next paragraph down. So if we go to the next paragraph down.
Let me call that out real quickly. All right, I've got that for you.
And about midway down, there's a sentence that says, there's no question that requirement is satisfied, meaning that we satisfied that the Wayfarer parties are harmed here too, and they're part of those allegations. And as alleged, all the Wayfarer parties have become figures of infamy because of Reynolds' statement, which were widely disseminated and understood to refer to them. And that's right from the First Amendment complaint. So it's not just that you were calling Baldoni names, but you were intending to taint all of the Wayfarer parties. And we said that in our First Amendment complaint, and that allegation should be enough for us to get past the motion to dismiss.
All right, so the first check mark here for Team Baldoni and attorney Brian Friedman is to show that their complaint was legally sufficient. And according to you, if you're sitting as judge, do you check that box off and say it is legally sufficient at this point in time?
I would. Yeah, I would say that there's enough there. But even if the judge disagrees with us and says, I think you need to do more, he definitely would give him leave to amend.
All right. So then the next issue that we saw in the opposition is this idea of opinion. So the next issue is it's not just opinion. What are we talking about here? Not just opinion, fact? I mean, what's going on here?
Well, if I were to say something really terrible about you, would it be okay as long as I say it's just my opinion? And defamation comes down to when you say something that's a verifiable fact, you can either find out the fact is true or false.
Okay.
But
run me through that one more time, because that's a very important point here.
So if I were to say that Bob Smith, I'm not going to use you this time.
No, go ahead, use me.
No, I'm not going to use
No, I insist.
Okay. Stuart Albertson, if I were to say, I'm not saying it, but if I were to say that Stuart Albertson is a convicted felon, that's a provable fact. Somebody could prove that you are, you aren't. If I assert it as if it's true when I know it's not, or I just was careless about it, then I'm going to be liable for defamation.
Or at least can bring a claim against you for defamation.
Yeah, and there's a good chance that you prevail on that claim. If I were to say Stuart Albertson looked like somebody who would steal my mom's money, I'm not saying you're a convicted felon. It's still a pretty nasty thing to say. Is that defamation? Is it provable that you look like somebody who could steal my mom's money?
Could I change one more fact here?
Yeah.
Let's say that I'm a famous movie star.
Okay.
Okay, so I'm very famous. Everybody knows me. Does that change your analysis as well?
It does, just because that's when you get into actual malice. And so if I'm saying things about you and you're a public figure, now I have the right to say more about you, and I can say more things that are not particularly nice and may not even be true in a way that I couldn't do against a private person.
Okay, so here we're going to go to page 10 of the opposition. And here we're going to deal with, and you let me know which paragraphs you want me to highlight here.
We'll start with the first one, just the first part of right there. So it's interesting because if you recall, Ryan Reynolds was saying, look, when I use the term S predator, it was just an opinion. It's not a provable fact. I'm just giving my opinion. I think the guy's a S predator, which of course I think is beyond an opinion. That's just my personal view of it. But here they're saying that Reynolds' attempt to recast his statement as opinion is belied by context. So you have to put these things in context. These statements were statements that at least implied undisclosed facts. All are susceptible to a defamatory meaning, namely that Baldoni had committed egregious offenses that warrant the label of S predator.
These are S offenses. I mean, it's so strong. And this Patridge versus State, tell me, I mean, look at what this case has. I mean, we should look up Patridge versus State. We didn't do that, but what does it say there? I mean, it's unbelievable.
So they provide 5 examples. Here's 5 examples that they're pointing out from case law. First of all, being wrongly branded as an S predator is defamatory as one of the most loathsome labels in society. Well, I would say so. I mean, it doesn't really matter what industry you're in. It's pretty loathsome to call somebody an S predator as if it were true. And then certainly in the entertainment industry in particular, just because of how big the Me Too movement was. And then the next one, there was one where they reversed the appellate court reversed an order granting a motion to dismiss based on allegations that defendant called plaintiff an S predator to members of the women's tennis team. Okay, that's pretty egregious. The court said, that's enough for a case to go forward. The next one, denying motion to dismiss defamatory claim based on statement that plaintiff was fired for being an S predator. So if I were to go around telling people Stuart got fired because he was an S predator, that's enough for a case to go forward. Court's like, that seems fine. And then denying a motion to dismiss claims based on statement plaintiff was S predator. So again, they're showing 5 different examples here where appellate courts have said that statement is enough for a case to go forward.
So when we get into not just opinion versus facts, and you're the judge looking at this particular issue, what are your thoughts after looking at the opposition?
I think there's sufficient allegations here for this to be looked at as a statement, a truthful statement, and not opinion. And ultimately, the jury will have to decide that. So I would let it go. I would not dismiss on that basis.
I think that's the strong point you have here is that this is a determination that the jury needs to make. And so unless it's just a bald-faced opinion that a court could look at and just make the call, I think the judge is going to have to say, look, this is a factual determination. We have juries for that. We're going to let them figure out whether this is opinion, whether it's, and I think they have opinions that are sometimes turn into facts, right? And so it's a very complex analysis. And so we're going to leave this to a jury to determine the distinction. So, all right. So we've gone over the complaint being legally sufficient. We've gone over. There
is one more thing though on that page, page 10, that was kind of interesting. I wanted to ask you about this. So
you want to pull it? Where do I need to pull it?
The very last paragraph on page 10.
All right.
And it talks about how context does matter. And I don't think the document's on the screen.
Oh, I got to get that up there.
There we go.
There we go.
Thank
you. The Reynolds made the statement to key WME figures in an effort to force WME to drop Baldoni. Okay, that's in the complaint. Reynolds' argument that his deep disdain for Baldoni precludes a defamatory meaning of his words is illogical. Why would it matter if Ryan Reynolds has deep disdain for Baldoni?
Well, I think it matters because that goes to what his feelings are and what he's trying to do here. And that gets to the actual malice. That gets the idea of, I want to harm this guy. And in fact, if it's true that he did go and call Baldoni an S predator, and that's the reason WME drops Baldoni, and this all on the surface looks like this is what happened, he's been damaged. And Baldoni's been damaged, and Wayfair and some of their people there have been damaged. And so they have a right to bring this forward and use this as evidence. And I think it's funny because didn't the deep disdain come from Ryan Reynolds' argument? It didn't come from Baldoni's argument.
So, and I really like what you said, because that's what they argue is that, wait a minute, deep disdain and in connection with these comments, that looks like actual malice. That goes to actual malice. I think what Ryan Reynolds is saying is that, well, of course, this is an opinion. I have a deep disdain for this guy. And so the more that I disdain him, the more nasty things I can say.
Yeah.
I mean, that's kind of that's why it's illogical.
Right.
It doesn't really flow logically.
I don't remember where Ryan Reynolds made that argument, but it looks like the motion at page 11. So I need to go look at that.
Yeah.
But if he did say that, that's a type of, I guess, somewhat of an admission. It's not a sworn, it's a motion. So that's something that people will want to talk to him, though, about in deposition.
And I guess he's trying to use it as, this supports the fact that this is just my opinion. But I don't think that gives you the right to go around calling people less predators.
Okay, so now there's another issue that comes up, and it deals with not substantially true.
Yeah.
And what is not substantially true? What's that issue about?
If you recall, Ryan Reynolds' argument, which I found interesting at the time, was that even if I did say this, it's substantially true. Baldoni is an S predator. And that was the big punch to the face that we talked about when we were going through Ryan Reynolds' motion.
Can I walk it? And I think what I remember reading was, if Ryan Reynolds did say S predator, it was an opinion.
Yeah.
But if it's not an opinion and it's a fact, it's true.
Yeah. Well, the first part was I didn't say it.
Okay.
But if I did say it, it was an opinion.
Okay. If I didn't say it, but if I did, it's an opinion. And then if it's not an opinion, it's a fact. And if it's a fact, it's true. And why would it be important that it be true for Ryan Reynolds'
because
benefit?
truth is an absolute defense to defamation.
Okay. So what does Brian Friedman, Team Baldoni, how do they respond to this, starting, I believe, on page 11?
Yeah. And really what they point out is that, and there's a sentence, if you see it right after a citation, sup 2D at 1288, taking the
Which
allegation.
paragraph is that, Keith?
It's the first full paragraph.
All right, grab that for you.
There we go. So taking the allegations in the First Amendment complaint as true, the court must on this motion. So the court cannot conclude as a matter of law that Baldoni is an S predator or the Wayfair party smeared Lively to retaliate her for the disclosures of supposed misconduct. So in other words, that's not something that the court should decide as a matter of law. That's something for the jury to decide. And the fact that Reynolds in his motion is trying to say, well, it's true, therefore I should be dismissed. Well, wait a minute. The jury needs to decide if it's true. You can't just come in here and say it's true. We need to look at the evidence first.
Is there anything else you wanted to look at on that?
Yeah, down below, if we go, let's go to page 12 in the first full paragraph on page 12 that starts, Reynolds' second argument is barred.
I think that'll get you there.
Yeah. And it's barred because Reynolds draws on excerpts from Baldoni's book, YouTube videos, and podcast episodes, none of which are in the First Amendment complaint. So again, this goes back to the idea that you must have things in the confines of the First Amendment complaint for them to be fair game and a motion dismissed. They went outside of that standard. And we mentioned that when we went over Ryan Reynolds' motion.
So let's go back to page 11 just briefly. And I think this is important because they're saying Reynolds' argument collapses under both scenarios. First, the things he does point out, that we can all look at is, number one, that a conversation Baldoni had with Lively at Sony's direction about her wardrobe choices. Okay, they're saying, does that equal S predator?
Right.
Okay. Number two, a suggestion from the film's intimacy coordinator relayed to Lively by Baldoni. And let me finish the next page. Let me call that out 1 second. Lively would not meet her about the mechanics of a particular intimate scene. Okay, so does that equal S predator? Okay, to the average person, does our jury pool think that any of the things I just covered equal that Justin Baldoni is an S predator. He's allegedly called costume sexy.
Yeah.
Does that equal S predator? Hiring a Shakespearean trained actor with an MFA in acting to play a doctor. Does that equal S predator? And again, I think what they're trying to point out here is that this was supposed to be a friend of his that was supposed to, be delivering a baby in a very intimate scene with Blake Lively with her legs open in the air, and so she's saying this is your best friend, and he just wanted to look at this, and they're saying, well, the guy's got cred. He's a Shakespearean trained actor and an MFA. So does that equal S predator? Jamie Heath, not Baldoni, showing Lively in preparation for a birth scene, a single clip from a home birth video depicting Heath's newborn son. And I think we've all seen a picture of this. Does that equal Justin Baldoni being an S predator? And then Baldoni's purported failure to deny biting and sucking of Lively's lip. And I love what they say here, even construed in the most uncharitable light, which would be the inappropriate standard here at a 12b6, these admissions do not show Baldoni is a S predator.
Yeah.
And then what you got to was, remember when they said, hey, let's take a look outside the four corners of the 12b6.
Yeah.
Let's look at a YouTube video that, Baldoni spoke about. Let's look at books that he's published.
Podcast episodes.
Why is it not appropriate at this stage, and we've already talked about this when we saw this happen, but why is it not appropriate for these outside extrinsic pieces of evidence to be looked at by Ryan Reynolds' attorney to defeat the Baldoni lawsuit?
There's actually two different standards that we have to look at here. So first of all, when you're doing a motion to dismiss on 12b6, the court's only allowed to look at the four corners of the complaint. The court is not allowed to look at any other outside evidence. Secondly, the court is supposed to take that, whatever's said, the allegations in the complaint, and assume them to be true. So you have to assume them. And that's why the paragraph that you had highlighted before, they went over all of those facts because the court has to take these as being true just for purposes of deciding on this motion to dismiss. And you're looking at all these facts and you're saying, okay, well, look at these facts. As a matter of law, do these facts suggest or admit that Baldoni's an S predator? As a matter of law, no, they don't. And so now if there was something in the First Amendment complaint that said Baldoni was convicted of, some crime that would suggest he's an S predator, that'd be different. But based on these here, and the reason they say uncharitable is you have to assume these to be true. So if you look at these and you assume them to be true,
take them in the worst way possible.
Yeah, I mean, they're not enough as a matter of law to get the case dismissed on a 12b6.
But what about the YouTube video? I mean, this YouTube video where they say, hey, Ryan Reynolds' attorney said, we've got him admitting that he's an S predator in this YouTube, this TED Talk he did. And they actually linked to a footnote in their moving papers here, the 12b6 they brought. Why is it inappropriate for them to use those arguments at this phase of the litigation?
Because it's not within the four corners of the actual complaint. So you have to look only at the allegations in the First Amendment complaint. We're not at the stage of the case where we look at evidence. That comes later.
So when they say extrinsic evidence, what we're saying is we don't look to outside evidence. We only look to what's in the four corners of the document, which begs the question, why did Ryan Reynolds' attorneys include those arguments in their 12b6?
Because it's the best thing they had. And I think, number one, I think there was some PR going on there. So there's a lot of public PR that we wanted to point out and show that, from their point of view, they wanted to try and paint Baldoni as a hypocrite. But in terms of a legal reason to do it, it's probably the best argument they had. I personally don't like doing that on these types of motions because I think you lose credibility with the judge when you don't stick to the proper standard. Because then the judge is saying, oh, you're talking about things outside of the complaint, and now I have to go through and look at every single statement you make and double check if it's in the complaint or not. It's just not a good argument standard from my point of view.
All right, so we're done now with the not substantially true issue. So we've crossed three issues off. Well, I didn't ask for your determination on the not substantially true issue. How do you think the judge is going to view this issue?
I think I would not dismiss the complaint based on not substantially true. I think that's for the jury to decide, and there's nothing in the First Amendment complaint that makes me think, oh, this is true.
So the next issue, Keith, I think is very good for this case against Ryan Reynolds. And it's whether California law should or should not apply to this case vis-a-vis Baldoni crew against Ryan Reynolds. The double-edged sword is going to come on Friday or whenever the opposition is filed to Blake Lively's moving papers, because we know that there's California Civil Code 47.1 that is very beneficial and helpful to Blake Lively. And I know people are uncomfortable hearing that, but we're going to tell you the truth. That is an issue that Team Baldoni is going to have to deal with and face. But here, 47.1 does not apply to Ryan Reynolds. He will get no benefit of that law. And it seems like there's some arguments about which law should apply. So what position does Team Baldoni take on whether California law should apply or not apply?
They take the same position they did with the New York Times. They want California law to apply in their lawsuit against Ryan Reynolds. They did the same thing with the New York Times. They wanted California law to apply in their lawsuit against the New York Times. There's a couple of reasons for that, if you want to get into them.
Yes, let's go for it.
One is California has a few causes of action that New York does not. And so there's the civil extortion, there's the false light, and then there's just a different parameter to the intentional interference with a contractual relationship. All of those favor Baldoni if California law is applied. And I want to make it clear that the court can apply California law. That doesn't mean the case is coming to California. So they're not going to send the case to California. They're just going to apply California law. The case is in New York federal court. And as far as we can tell, it's going to stay there. But there is this question about the conflict of laws and whether New York or California law will apply. And Baldoni very much wants California law to apply.
All right, let's take a look at what was said in the opposition. And Keith, I'm going to move to page 3 real quickly and just do a quick call out here.
Hey guys, Daily Dose of Dana, she's here watching. I saw the
fantastic.
Tilted Lawyer is here watching. And Dana says, I want them to come on my show. It's her officially asking right now.
Well, Dana, we've been waiting for you to ask us, so we'll take you up on that.
I think it's Donna, though, not Dana.
Oh, sorry.
Oh, that's my mistake.
Oh, is it? I can't see. My eyes are small. My eyes are small.
Your eyes are small.
My eyes are small.
Beady eyes.
Beady eyes. That was funny. That was not nice of you.
No, it was not.
So, yes, we want to come on your show. Let's talk about the California law and how it works. And since we're in federal court in New York, here, Baldoni's team says the choice of law rules of New York apply because we're in federal district court in New York. So we have to look to New York's choice of laws.
Conflict of laws.
Choice of laws.
Yeah.
And how that works. Okay. And say they go on to say the first step is to determine whether the laws of New York and California conflict. So do the laws of New York and California conflict on this claim?
Yes.
They do. Okay. And so they go through and they point out that the laws do conflict. And now we get to the pages you wanted to talk about. Where do you want me to go?
On page 4, near the bottom, what you have highlighted there. So though New York may have some interest in this action because Reynolds resides in New York, California has a much more significant interest because nearly all of the plaintiffs are residents of California or have their principal place of business there. And the two corporate plaintiffs are both incorporated there. So it's the same argument we saw when they were opposing the New York Times motion to dismiss, which is the Baldoni and the Wayfair parties, they live in California, they do business in California. Their reputations feel the most harm in California due to defamation because that's where they live and work. And therefore, California law should apply.
Okay. And then you wanted to look at the next page as well.
Yeah, at the very top there. So, and or their principal place of business. So the plaintiffs suffered injury to their reputations in California, and the economic losses to the plaintiffs were felt in California. So again, the argument is California has a bigger interest, or the California laws and the California plaintiffs have a bigger interest in this defamation claim because that's where they live, that's where they work, that's where their reputations are most harmed. So California law should be applied by the court.
Right. So, and we wanted to go to page 14 and 15 as well. Why don't you tell me what we were looking at there?
Let me scroll down to those because
did we cover this issue enough, you think?
Pretty much. I mean, what was going on in those other pages is they also want California law to apply when it comes to these other claims, things like civil extortion, false light, and we'll get to this when we get to the interference with a contractual relation. That's where there really is a difference between California and New York.
Okay, well, why don't we move on? But I do want to get your assessment. Should California law apply to this case against Ryan Reynolds?
I would say so. I think the arguments for why California is the appropriate law to apply makes sense to me. I think that people who are harmed by defamation are most harmed where they live and work. That's where your reputation is, hurts you. So it makes sense that California law should apply here. What do you think? Do you think that that'll be?
I think California law will apply,
Yeah.
and of course that's a double-edged sword that we'll be dealing with in a future soon podcast on 47.1. Okay, so let's talk about these additional claims. There's 3 more things we want to cover here, and then we'll just get into the discussion and answering questions. The additional claims are valid, and this has to do with false light invasion of privacy. It has to do with civil extortion and tortious interference with contracts and economic damage. These are kind of the boring claims, I would say, that's going on here. But let's deal with civil extortion first. That's page 17. Why don't you walk us through what you wanted to look at there?
It's a unique cause of action for California. Civil extortion is actually based off of criminal extortion.
Where are we at in the opposition?
First paragraph under D.
Okay.
And extortion is the obtaining of property or other consideration from another with his or her without his or her consent, induced by a wrongful use of force or fear. So what the claim is in the First Amendment complaint is that Ryan Reynolds and Lively, that they forced Wayfair parties to do certain things. Some of it is the takeover of the movie, but some of it also is that they demanded that the Wayfair parties issue an apology when Blake Lively got bad press.
Right.
Wayfair parties refused to do it. And Ryan Reynolds said, if you don't do this, then the gloves are coming off. And that then becomes the basis of, oh, that's an extortion claim. I think that there's probably enough here to have where they probably did plead an civil extortion claim. I'm not sure that it's the strongest claim that they have against Ryan Reynolds, but I think that there was enough here to at least cite to it.
All right, let's jump to the false light invasion of privacy on page 18. What do you want me to highlight there?
The first paragraph under E.
All right, we got it.
So what they're trying to say is that false light is a separate cause of action from defamation. They're a little different. And false light is also part of invasion of privacy. So the idea of false light is somebody, like if I were to go in and take your medical records, and let's say there's something embarrassing in your medical records, and I put it out for the world to see, and it then paints you in a false light, and people start thinking of you poorly because of it, that would be a claim for false light. It's a little different from defamation because it doesn't involve me saying something necessarily, but it does involve me embarrassing you. And you can see that it says kind of halfway down there that both the false light claim and libel claim are based on the same alleged defamatory statements. But here, by contrast, the Wayfair parties allege not only that Reynolds conspired to defame them by means of false and harmful statements, but also that Reynolds and the others conspired to place the Wayfair parties in a false light by means of false statements and distorting factual statements beyond recognition into falsehood. So it's based on a lot of the same facts, but it's a completely separate cause of action. And so they're saying we have a right to bring this under California law, and it is its own cause of action.
And New York doesn't have something similar to this?
It does not.
Okay. So then we get to tortious interference with contracts and economic advantage, and that's going to be page 22 and 24. And why don't we go to 22 first, and why don't you tell me where you want me to call something out there?
Right after number 3, the first paragraph under number 3, this is an interesting cause of action. I just want to point out what the elements are to prove this. So to get a tortious interference with contractual relations,
by the way, what's the basis of this claim? What are we talking about?
It would be where one party comes in and gets in the way of a contract between two other parties and intentionally does that to try and force a breach.
And is this the WME issue here?
Yeah. So this is where Ryan Reynolds allegedly forced WME to drop Baldoni and told him that you're working with the S predator, and he came in here and he interfered with their contractual relation that Baldoni had with WME.
Okay, so let's walk through the elements.
So you need to have a valid contract between the plaintiff and a third party. The defendant has to know of that contract. The defendant has to intentionally act to try and breach that contract, or, and this is the important part, breach or disrupt the contractual relationship. And number 4, actual breach or disruption of the contractual relationship and resulting damage. That's where there's difference between California and New York. New York requires an actual breach of that contract, whereas California says you can either have an actual breach or a disruption of the contractual relationship. So you don't necessarily have to have a breach if there's just a disruption that causes a problem there.
You want to look at page 24 as well.
Yeah, and that's the distinction. That's again why they want California. And so well, wait a minute. I want to look at, yeah, let's see, page 24, right under number 4 there.
Okay, calling it out.
So in this one case, they're pointing out a case, the California Supreme Court held that to state a claim for tortious interference with a contract terminable at will, a plaintiff must plead an independently wrongful act. So there's a further issue with the contract between Baldoni and WME. It was either party could terminate it at will, apparently. It wasn't for a term of years. And so Ryan Reynolds was saying, well, so I interfered with the contract. It could have been terminated at any moment anyway. Who cares? And what they're pointing out here is that the California Supreme Court has held that you can still bring this type of claim, even if it's terminable at will. You do have to plead an independently wrongful act. Well, here, the First Amendment complaint does allege an independently wrongful act by the fact that Ryan Reynolds said what he said to the WME executives.
Okay. All right. So we've got these additional claims, we're calling them. These are the boring part of the case for me, but I'm glad we could go through them for everybody. Do you think that these claims end up getting through a California law as applied?
I think if California law is applied, there's enough here to at least state a claim and get past the motion to dismiss.
So 2 other issues, Keith. The first one is Ryan's acted with malice. Do we need to pull up the complaint on that, or do we just want to talk about that?
No, we can just talk about that. And I think we've mentioned some of the things.
Okay. So do you think that Baldoni has shown through his opposition here that there was actual malice on the part of Ryan Reynolds?
I think from an allegation standpoint, he has. And I think his allegations about, forcing Wayfair to do an apology when Lively got bad press. I think just the nature of the statements that Ryan Reynolds allegedly said, calling Baldoni an S-predator, I mean, that shows a lot of malice to me. And he did admit in his motion to dismiss that he has a lot of disdain for Baldoni. I mean, it seems like that, as you said, could support malice. And the overall kind of takeover of the movie. In other words, there's an ulterior motive here. I think that could also show malice. So from a pleading standpoint, it seems like there's enough here to let it go forward.
Okay. And the last thing was their attorney's fees. Ryan Reynolds basically was asking for attorney's fees under some type of an anti-SLAPP statute. And I think, just in brief, my understanding of that is the federal rules of civil procedure are more lax on filing requirements. And because those cause friction with the state anti-SLAPP laws, the federal rules are going to trump those. And so the anti-SLAPP, it doesn't apply here. At least that's the argument that Baldoni and his crew are making. And so they're saying, even if we lose, which they don't think they're going to lose, this is not a slappable offense. So we should not have any type of attorney's fees award made against us.
Yeah.
So this is definitely not the teeth of 47.1 that we see with the whole Blake Lively side of things, which we're still waiting for that opposition to that 12B6 to come in.
Yeah, that'll be in any day now. We have what, 4 oppositions now? They already filed their opposition to the New York Times. They're going to oppose, I'm sure, the one filed by Leslie Sloan, which I think is due today or tomorrow.
Today, and then tomorrow, I think, is Blake Lively.
Yeah. So that means that they're facing these 4 motions to dismiss. So it's Baldoni versus these 4 motions to dismiss. And I know that we were talking before we came on about these different ideas when it comes to managing a case like this. And I know you had some interesting thoughts about that. What were your thoughts just in terms of how do you manage a case that has this much going on in it?
Yeah, before we get to that, let's put a button on this, and that is we now have covered the opposition. And what are your thoughts? I mean, what does the judge say? No, I'm not persuaded by Ryan Reynolds 12B6. This case is moving forward. What are the other options for the judge?
The judge could grant the motion in part and say, I'm going to grant it as to a certain cause of action, but not the other ones. And then I'm going to allow Baldoni time to amend and fix up his pleadings. So that's possible. It seems like most of these should make it through a motion to dismiss. There was a little bit of argument about, did Ryan Reynolds really say something directly about the Wayfarer parties? I think they presented a good argument on that, but I could see where a judge might grant, the motion to dismiss as to that one cause of action and ask Baldoni to amend. But yeah, other than that, I guess the judge could dismiss the entire complaint and ask him to amend. I don't really see that happening relative to Ryan Reynolds.
And I feel that Brian Friedman feels confident that they can plead around the things, at least against Ryan Reynolds here.
Yeah.
They can plead around this. They're going to get this through.
Yeah.
It's at least going to go to motion for summary judgment next. They'll probably get past that, and they'll probably get into this case in front of a jury, at least against Ryan Reynolds.
Yeah, I mean, I think the case against Ryan Reynolds is strong. And when you're looking at this opposition, and I'll be honest, I wasn't as impressed with this opposition as I was the opposition that Baldoni filed against the New York Times. It was really well done. This is a perfectly good opposition. There's nothing wrong with it, but it wasn't the same. I mean, that New York Times one was just outstanding. But in some ways, this one didn't need to be the same because the arguments against Ryan Reynolds aren't as difficult in my mind as the arguments against the New York Times, where they've got the fair reporting privilege and all that. So you kind of needed to bring in a heavier kind of hammer for the New York Times than you probably did for Ryan Reynolds.
So our prediction to the jury pool is that if Baldoni wants to move forward in his claim against Ryan Reynolds for defamation, for calling him an S-predator, we think that will end up in front of a jury at some point in time, unless the case settles. And then a jury will determine whether there was defamation by Ryan Reynolds, if in fact he did say to somebody that Justin Baldoni was an S-predator. The evidence appears to show that that's likely that did occur. But again, the lawyers have to do their jobs in deposition and discovery, and then, of course, at trial. And they got to get that evidence in. And then, of course, they have to be good at questioning, too. I don't know if you remember watching the Johnny Depp trial, and Amber Heard's attorney, she had a very difficult time asking questions on direct exam. She had a witness and that she put up, and I don't know if you saw this or not, but she kept asking cross questions because she didn't know how to ask the questions on in a way that wasn't leading.
It's easier to lead.
And she basically just gave up after like 20 objections were sustained by Johnny Depp's attorneys and the judge. The judge sustained all their objections. She just gave up and sat down. And that was somebody that was important to her. She was trying to get some evidence in. And of course, that evidence doesn't come in. So there's not only the rules of evidence that keep evidence out, there's the actual art that lawyers bring to this.
Right.
And do they have the ability? Because some judges are more strict on some objections.
Yeah.
Some, hearsay, foundation, those things come up all the time in trial, and you have to learn how the judge views those things.
Well, it's easier to ask questions on cross because you're leading, and so you're giving the answer. And so really it's the lawyer who's testifying, not the witness.
Right.
To do it on direct, it is an art form. Both of them are art forms, but direct, I find direct to be a little bit more difficult at times, especially if you have a witness who isn't getting it. Sometimes you're trying to tell the witness, okay, let me direct your attention to this day. Can you tell me what occurred? I don't remember. It's like, come on, we worked on this.
Right. So, okay. So you'd asked me a question and I forgot what it was.
So you and I sit around and we talk a lot about strategy on cases. Like we call it turning the crystal. We try to figure these things out. So I'm looking at this, and Baldoni's facing 4 different motions to dismiss: the Times, Lively, Ryan Reynolds, Leslie Sloan. And I'm just looking at what he's facing. I want to know from you, what is the strategy here? And you had some very interesting thoughts in terms of the different ways that you could go about this case. Well,
first, you can continue with what you're doing, and you can fight the New York Times. You can fight Sloan. You can fight Ryan Reynolds. You can fight Blake Lively. That's a lot of attorney's fees. That's a lot of time. That's a lot of landmines you got to cross to get to a jury and win your case. Or you could look at this more strategically. And this is just 2 different legal views. So some lawyers want to throw everything against the wall, see what sticks.
Yeah.
And then they want to take that and put it in front of a jury. What you and I have done through the years is we've not thrown everything against the wall, contrary to a lawyer that once said that we threw everything against the wall when we had 2 or 3 claims. But we'll take 2 or 3 claims that really matter. We think they're all good claims. And then even before trial, we'll meet with the judge in chambers. And sometimes we'll say, hey, judge, we're going to let this 3rd claim, this false light claim or whatever, it's kind of a minor player here. It's just going to confuse the jury. They might think it's more important than it is. They might think my real claim is not as important as it needs to be. So we're going to waive that claim. So this happens all the time. The issue is that this case has a lot of public eyeballs on it. It has a lot of people in our jury pool that watch it daily. They really enjoy the process and watching and learning. And so the lawyers here are under the gun for everything they do. So can Brian Friedman have the same freedom he would have in a case that wasn't in the public spotlight? If he didn't have a case in the public spotlight, if he runs up against a lot of things with the New York Times, with the fair reporting privilege, and whether New York law applies or California law, and you see how difficult that is just 60, 70 days into this case, do you say, maybe we don't go after the New York Times? Maybe we let the New York Times out for a cost waiver, but we still use them for evidence in the cases that we have remaining and the causes of action we have remaining. Which leads me to look at the case you have against Blake Lively. And again, we're going to talk more about that as soon as the opposition comes in from Team Baldoni to her 12B6. But this California law, this 47.1, it's funny, Keith, you and I think, were the first ones to talk about it on YouTube. And then there were a lot of lawyers that had, wanted to talk about it and they wanted to say whether it applied or not in this case. This 47.1 is a problem. It's a real issue that Brian Friedman is going to have to deal with, that Baldoni is going to have to deal with, their whole set of clients over there are going to have to deal with, and they're going to have to talk about the strategy on how best to move forward. And I'm just saying, from a brainstorming standpoint, does it make sense to reach out to Blake Lively and say, we're going to withdraw the defamation claim against Blake Lively? Because this law is just unfair. It puts us at an unfair advantage. It raises so many issues that we're going to have to fight for the next year and a half that we really don't want to have to fight. So we'll withdraw it if you promise a cost waiver and that you won't come after us for attorney's fees and all of those things. Because if you withdraw a claim without getting the other side to agree to it, then Blake Lively would be what we call the prevailing party. And if she's the prevailing party, then she gets punitive damages possibly. She gets treble damages possibly.
Attorney's fees.
Yeah, attorney's fees. It's a nightmare. But the idea would be you let the New York Times go, but you still can use them in your case. You take the defamation claim against Lively, you toss it. You still defend yourself vigorously against the claim she's made against you for SH. There's no, you're not putting yourself into handcuffs there. And then you take all of your guns and you point them at Ryan Reynolds and you point them like a laser, like a very focused laser. This guy's got deep pockets, apparently. The news says he's worth $1 billion or whatever it is. I don't know if he's worth that much, but let's say he is. He said something that was just so over the top, if it's true. If he went around telling people that Baldoni was an S predator, you've got him. And if a jury believes that, they're going to hammer him because those are horrible things that you would say, but you could ruin somebody's reputation forever. They could never get their reputation back under the wrong circumstances there. And you're going after him. You're still making your point. He's married to the person you also are upset at for bringing what you believe is a false claim of SH against you. So she's still impacted by all of this. It's not like you're just walking away from her and letting her, run away happy as ever. You're going after the person that you have the best claim against, and you're putting all your firepower there. Man, I think there's some wisdom. At least it would take just from a moment, put this all on the table, look at it and say, is this the way to move forward in this case? Rather than fighting 5 front wars or 4 front wars or whatever they are. How well did that work out in history when you're fighting the Russians and everybody?
Not great.
No, it doesn't work out great.
Yeah, as
Napoleon knows, as many people in Europe know, you never fight a 2-front war in Europe, right? So I know people are going to flame me and say that, oh, you're giving up and you don't have the backbone for this. No, I'm looking at this saying, what is the best way to vindicate his name and to get damages and to go after somebody that actually has the ability to pay those damages? And are we fighting too much all over the place on all these other issues when we need to solidify what we're talking about here and going after Ryan Reynolds?
So you mean concentrate your firepower on the biggest target?
Yes.
And of the Times, Lively, and Ryan Reynolds, you're saying Reynolds is the biggest target or the best target?
He's the best target for getting damages. as far as Lively goes, you vigorously defend yourself against the claims that she's made against you.
It's interesting too, because the Times has a privilege, fair reporting privilege. Lively comes in with two privileges, section 47 and 47.1, which is so devastating. Where's Ryan Reynolds' privilege?
No privilege.
He has no privilege.
No.
It's kind of, he's exposed in that sense.
Yes. And what he said, again, if true, is devastating. I mean, there's not too many meaner things or more awful things you could say about another human being, especially in the entertainment industry, but anybody. This is over the top. And I think a jury will punish somebody for that type of statement. And, Ryan Reynolds, when we get to the punitive phase of this case, if there is punitive damages, he's worth a lot of money, and that'll have to be looked at. And people are going to look and say, hey, can we go after him for punitive damages for that statement?
It is interesting. And I think you would really concentrate the focus and the firepower just on Ryan Reynolds heading into trial when you're saying, this is the person, this is the wrongdoer right here. I mean, it's an interesting strategy.
So I don't know what the jury pool thinks of this. And again, my apologies to anybody that's offended by my thought here. I'm not trying to offend anybody. I'm just trying to think, how is it that if we were handling this case, how would we figure out how to go after people and hold them accountable for what's going on here?
Well, the court may make up your mind for you as to the New York Times. So if the court ends up granting that motion to dismiss, you may not have a choice. So the court may narrow your issues for you if you don't choose to do them yourself. And you don't necessarily have to make that decision right this minute. You can go ahead and oppose the motion to dismiss by Lively.
Yes.
This could be a strategy that comes next month, next year, or right before, like you said, right before trial. The problem is this 47.1 does give attorney's fees to the prevailing party. And so if you are going to withdraw that claim and concentrate all your firepower on Ryan Reynolds, you're better to do it earlier rather than later. But it's a big strategy decision.
Yeah. And I heard an attorney this week say that 47.1 would only apply after the jury has made its determination. It's true that is a point in time that 47.1 could apply in a case, is after a jury makes a determination, because if they found that Blake Lively is the winner and she's deemed the prevailing party, as that's defined under California law, then she would get attorney's fees, treble damages, and punitive damages. But also, if she wins at the 12B6 motion, which we don't think she will, but if she were to win at 12B6, if Baldoni were to dismiss without getting a waiver from her as to those issues, she would be the prevailing party. If she wins that motion for summary judgment, she would be a prevailing party. So there's lots of times in the timeline where she could theoretically become the prevailing party under 47.1.
And I think we've made it clear up till now that, based on all the evidence we've seen, we certainly favor Baldoni's side of this case. I think that he has the facts and evidence on his side based on everything that we've seen. We haven't seen all the evidence. There could be something else out there. So we're trying to think of this, and I think your comments were designed towards what would be the best for somebody in his position in order to kind of concentrate your firepower, hopefully get the best result. And also, one of the things lawyers are big about is let's not expose our clients to risks that we don't need to be exposed to. So can we shut down some of these risks while still going after the people we need to go after and getting a good result?
Right.
It's a lot to think about.
A lot to think about. There's lots of moving parts here. This is the major leagues of litigation.
Yeah.
Producer Eric, do we have any questions?
We got a ton of great questions. A ton. I'm going to try and do these chronologically for people who might have been waiting a long time. Maggie Lang says, is there a deadline for when the judge rules on these motions to dismiss?
So we just got the opposition. There's going to be a reply that's going to be, so Ryan Reynolds will have a right to file a reply, and then the judge will issue a ruling. I think there's the timeline. I forget what it is in federal court. I want to say it's something like 30 days, but he'll make a ruling before that. And so once all the pleadings are in, then he'll make a ruling.
Yeah, federal court's fairly simple on that. From our experience in dealing with it, in fact, many times they don't even give you oral argument. Here, you're probably going to get oral argument, but many times they don't. They just make a ruling. Like in state court, you almost always get an oral argument on your motions. Here, that may not be the case.
That's important to point out. Yeah, the court can rule on these motions without oral argument if it wants to.
Next up, this was from Luna. She said, does the unclean hands doctrine mentioned by Candace Owens today, can that be applied to SH cases? I don't put anything past you guys on knowing these kind of devices and things like that. Unclean hands doctrine.
Well, I guess I didn't watch Candace's show, but I'm assuming what you're meaning is there's bad behavior on the part of Blake Lively, and I know there's been some videos floating around of her grabbing the crotch of some other actor when that wasn't called for in the script or something. I don't know if that's true or not. There's also that maybe she was involved in inducing Baldoni to get involved in the SH issues that she's pointing out. So I don't know, Keith. I don't know about SH claims and unclean hands. What are your thoughts?
Unclean hands is a defense to the imposition of an equitable doctrine, and everything that we're seeing here are legal doctrines, not equitable doctrines. So I can't think of a scenario where unclean hands is going to be helpful as a defense for Baldoni, because these are all legal claims. But I guess in theory, there might be some equitable claim out there that maybe I haven't seen yet, but I don't think it's going to apply here.
So there's law and there's equity. And so you're saying all of the claims here are legal claims. And so, if there's any defense against those, they have to be affirmative defenses, I suppose.
Yeah.
And then if there's some equitable claim that somebody's asking for, if somebody else is acting badly, you could point out that that person is what? Has unclean hands.
Yeah. So there's like an equitable doctrine of promissory estoppel. Well, somebody made a promise and you relied on that promise and you did something, but then they reneged. And so that's an equitable doctrine. And one of the things that's a defense to it is unclean hands. Well, I promised you something and you relied on it, but then you did something bad to me. And so you're just as bad as I am. So nobody should get equity.
We'll have to watch what Candace had to say about it, but it sounds like let's watch first and then we can report back.
And it could be that she was not using it in the technical sense, but using it more as a broader definition for what a defense could be.
Speaking of watching, I'm going to guess no, but I'd seen this. What do you guys think about the lawyer in the Max documentary that says that Blake has the stronger case? And this is something that just came out recently. I'll put it on screen. It looks like this. I haven't watched it yet, but I know it's out now on Max. No free ads, but I guess.
I mean, I could take a shot at that if you want, or do you have go ahead if you have an answer.
Well, I was just going to say my wife told me it was on. I'm like, I don't think I need to watch it because I think I know everything about this case more so than this documentary. And then apparently the documentary was pretty shallow in its understanding of the facts.
Yeah, I think
what I heard.
I think it's somewhat superficial. I think if you know the facts of the case, you're not going to learn anything new. I do think that because of 47.1, I do think that Blake has a better case against the defamation claim that Justin and crew have filed against her.
That's the defamation.
Just the defamation claim. Yes, because that law is so strong. It's a brand new law, January 1 of 2024. Every law has its unintended consequences. And this would, in my mind, from a personal standpoint, I feel sympathy for Justin Baldoni. And I think that the facts, as I've seen them, they support him. So just from a personal standpoint, I want to put that out there if somebody hasn't already picked up on that. But that doesn't keep me from looking at the law and saying this 47.1 is an issue. And it's actually built for this exact reason, the precise reason where somebody makes an SH claim against somebody else and that somebody else gets their feelings hurt and gets upset by it. And they turn around and sue that person for defamation. That's exactly why this law is here. And so the problem also with this law is it has all those teeth behind it. And it's just too much for the average person, even a well-paid actor and director, to take on to that exposure of being hit with all those damages.
But what about the SH claims? Because my understanding, and I didn't watch it, but from what I understood, what the lawyer said is that it didn't sound as though maybe she knew all the facts of the case. I don't know.
I haven't watched it. I would say that the SH claims do not look strong for Blake Lively.
Yeah.
But go ahead, Eric.
Sorry, I was just going to say all the people in the chat are saying it seemed rushed and vague and a little shallow. So,
okay.
Yeah, you'd have to know all the facts to, give an opinion. It didn't sound like that was the case.
Yeah. Anna Fan says, I practice tax law and I've terminated representation when a client lies or there's no case. Why isn't Blake's lawyers, why aren't they doing that? Don't they have a duty to tell her the truth? Anna Fan, tax attorney. I like this. This is like advertising. I see what you're doing, Anna. I like that.
That's awesome. Thank you for your support, Anna. I really appreciate it.
By the way, Anna, I have an LLM in tax. I don't use it, but I mean,
there it is.
There it is. I've never been able to say
Georgetown
that
too. Impressive.
Georgetown University. Yes.
Very impressive. One of the top 3 tax schools, I think, in the U.S.
So why haven't, in answering Anna's question, why haven't, if you assume that Blake Lively and Ryan Reynolds are lying, why haven't their lawyers fired them?
Well, either they don't think they're lying, they think that they still have a case here. they're holding on to, some of the allegations in Lively's complaint, thinking that they're going to be able to prove those up with evidence. So maybe they're just hoping that that's going to happen. And, how do you, they're high profile clients. I mean, you're not going to just kick them out the door, I suppose. I don't know.
Yeah, and I think there's a distinction here in law school. We're all taught ethics. Most people don't know that lawyers are taught ethics in law school, and they even have to take ethical testing before they become lawyers. And part of that is when a client does tell you that they're going to lie, or they are lying and they plan on lying on the stand, there's some rules we have as lawyers because we're officers of the court. We cannot help them further that lie, at least on the stand in court. But most cases settle. 98% of cases settle. So if your client's lying and a bad person, that doesn't mean they don't need the help of a lawyer. You're there to help them. And so you're trying to resolve the case for them. So I think you could ethically represent somebody who's a liar, a cheat, and a fraud. You could ethically represent them as long as you're not representing those lies to the tribunal as truth.
Yeah, as long as you don't put them on the stand or put that in declarations, you can't do that.
You can put them on the stand, by the way, but you actually have to ask them questions in a narrative. And everybody knows why you're asking them questions this way, because they know that they're lying and you don't want to be responsible for that.
There's an actual procedure for that, which is kind of interesting.
Yeah. Thank you for the question, Anna.
We got a few more great ones here. Little Panda Cup, I like this name. They donated. By the way, guys, you know what NOK stands for?
Is that North Korea?
It's a Norwegian kroner.
Oh, so, sweet, nice,
very cool.
How has the legal tone in filings from either or both sides evolved, and what might this reveal about strategic shifts or internal pressure? You guys have kind of touched on that, but you want to address it?
I mean, I think that we're seeing the way I viewed this, Keith, is that Ryan Reynolds was over the top in his 12b6. Because he's basically saying, not only are you an S predator, you've admitted you're an S predator, and here's the evidence outside of the pleading, something I'm not even entitled to bring into this argument.
But
I'm going to bring it in
anyway
because I want the public to read this and to really dig it into you. Right. I didn't like that tone at all.
No, and it did smack a little bit of desperation of wanting to just punch back just for the sake of punching back. And, like you were asking me, why was all this stuff included in the motion when it's so far outside the four corners of the complaint? Because they wanted to. They wanted to make it bombastic. I think, and I do think that I picked up on a little bit that the opposition that Baldoni filed to the New York Times, I mean, it was very well put together, very involved. This opposition against Ryan Reynolds, it's good, don't get me wrong, but it's not the same level. And so you almost get the sense of the Baldoni side saying, we're not so worried about this Ryan Reynolds one. But the New York Times one, we put in like a heavy dose on that one.
I also think the tone of Brian Friedman in his interviews has been very good. And I know the court had cautioned both sides or all sides here, the lawyers to chill a little bit in the press. Ezra Hudson, who I have admiration for, and I've taken heat on that. I think that she did a fantastic job in her Blake Lively 12b6. And of course, we're looking forward to the opposition of Team Baldoni. I actually reached out to Ezra Hudson via email to see if she would come on our podcast because I wanted to interview her and talk to her about this case. But I have not heard back from her, and I don't think we will hear back from her.
No, I don't think you will.
But Brian is still out there. Brian Friedman is still out there doing interviews, and I find him to be easy to listen to. He seems to be a guy that talks with common sense. He doesn't get real excited. So the tone from him is good. I'm just wondering, is there anybody on Blake Lively's side? Is there anybody on Ryan Reynolds' side, or even the New York Times for that matter, that want to come on our podcast and talk to us and talk to our jury pool about their views of the case? Because if Brian Friedman is out there talking, and by the way, Brian Friedman, you're invited as well.
We did reach out to Brian Friedman.
We did, and we've not heard back from him.
We have not, but he is doing quite a few interviews.
But the point is, we would love to see some more interviews for people to hear this. And then again, my encouragement to Brian Friedman, my encouragement to Ezra Hudson, and everybody is to bring the temperature down here where you can, and see if you can get this case resolved. That's what really needs to happen.
And I would say for the filings we've seen on the Baldoni side, they have been, I think, a little bit more reasoned, a little bit more measured, sticking kind of to the legal concepts more so. I mean, the opening paragraph of this one obviously had that statement. But other than that, I think that Baldoni's side has been a lot more reasoned and measured and restrained in a good way. And I feel like the Ryan Reynolds one in particular is just over
Yeah.
the top.
I will say the strongest legal writing I've seen is from the New York Times attorney. I don't recall her name.
That was a good one too.
The 12B6 that she drafted for the New York Times,
Yeah.
she did a very good job. And then I do think Ezra Hudson, if she's the one that actually drafted, this is all a team approach, folks. You know, there's associate attorneys involved, there's paralegals involved, there's other partners involved. There's a lot of wordsmithing that goes on in putting these filings out there. So there's lots of people that should get credit for the good hard work that's being done on these cases. But I tend to agree with you. I think the easier briefs and the ones that have just kind of done what they need to do have been on Baldoni's side. But the better writing in my mind has been through Ezra Hudson. And again, I can't recall the attorney's name.
The Times brief was good, and I thought it was well done until I saw the opposition by Baldoni, and that opposition was equally good, and that was really impressive. So yeah, a lot of really great briefing going on.
This one was from Jules. She said, I know we've talked about jurisdiction sort of ad nauseum, but she said, do you think that Brian Friedman for Blake's case can use New York law because the SH allegedly happened there? She also said, can you cover other popular cases going on like Karen Reed, which I think just started its retrial today or yesterday, but it seems like there's a demand for it. I don't know if you guys have time, but.
Yeah, that's the hard part, is just trying to find the time. I mean, I think the SH claims, those could be potentially under New York law versus California law. It'll be interesting to see how the court treats those, and I'm sure they'll be arguing that. What I'm interested to see is how are they going to argue the defamation lawsuit against Lively? Because so far for the Times and Ryan Reynolds, they've won California law. Are they going to argue something different for Lively? And it's kind of a tough thing to do now, because you've kind of said, all of the damages that we suffer from defamation happen in California because that's where we live and work, except for the defamation that we've suffered from Lively. It's a tough argument. It's a tough needle to thread on that argument. But maybe it'll be interesting to see what they say. As far as the SH claims, they could be heard under New York or California.
It could be New Jersey as well.
Yeah, right. Yeah. So we'll have to see how the court rules on that. I haven't seen any argument on that from Baldoni's side yet.
Okay, we're getting towards the end, but Apri Medina said different state laws may hold for different suits, but as they combine all of the suits into one large court case, how does a judge in court keep track of which laws are applying to what aspect?
I mean, this is the difficult part. And, you know, as Keith pointed out, that each claim is measured against each defendant and to see which law should apply. This will be a complicated case to try. And the question is, and it probably would be tried all at once because of judicial efficiency. You could, I guess, carve out part of the case over here and carve out another part of the case over there, but it'll be difficult. You're gonna have to keep track of all these issues.
What it really comes down to is the jury instructions. And so you're going to put, if you're using California law, for example, you're going to say, okay, we are going to go with civil extortion because California has that. That's going to be something that the parties will be allowed to put on evidence for. And then the jury will get an instruction on what civil extortion is and what they need to find. So it really comes down to the jury instructions more than anything, I think.
Yeah. And I guess there'd be a different set of, voir dire may be different. I don't know.
Could be different. And the type of evidence that's being allowed to be presented would be different.
And of course, you as lawyers are trying to keep track of the elements you need to prove for this particular defendant or plaintiff. Yeah.
I hope somebody's preparing a spreadsheet because you're going to need it.
Well, in response to that Karen Reed stuff, people are saying, I mean, it's huge. It's been going on for years. So it's like you'd have to read so much that already happened. And Jordan says more interested in Congress and Trump info than Karen Reed. So that's, one opinion.
That's good.
We talked about some of those things. Jenny said, would real malice interfere with the application of 47.1?
Well, yeah. In fact, that would be how you'd fight back. Is you got to show two things. If you're Justin Baldoni, you got to say that these things that were said, the defamatory statements were said with actual malice, and that she didn't have a reason to file her SH complaint at any point in time. And those are both questions that go to the jury. And so you end up in front of a jury. The problem is if the jury holds against you, the outcome against Baldoni and team would be excruciating to go through. So I think that's what we're facing. And, many people have talked about how 47.1 is just a bad law. It may be a bad law, it may be a good law. The point is it is the law and it's applying to this case. And so Brian Friedman and his team are having to analyze that and figure out how to move forward from here.
Awesome. Here's a couple more that are outside this case, but does your firm do estate administration / probate non-litigation?
No, we only do litigation. So we only take on cases where there's problems, but we know a lot of people who do the non-litigation stuff. So we can always hand out referrals if people need help.
Absolutely. Well, hey, I think we can wrap up the show. I'll put a couple of these comments on screen. Marie said, "Yay, caught alive with these two brilliant and balanced lawyers."
Thank you,
Huh?
Marie.
Thank you.
And this was before things got started, but Aisha said, "Always wait for you guys to post after legal filing goes public."
Nice.
And what else? You two gents are fantastic and do a truly outstanding job. Thank you for your help and for sharing your knowledge and keen insights.
What a great name, Buttercup.
Thank
you.
Buttercup.
Appreciate that.
And I like this one. It's from Joyce. She says, "My brain cells multiply exponentially when I watch A2L."
Well, that's good. That's nice to hear.
Joyce, thank you. I've heard we're boring, so
Yeah.
Teach their own.
Well, great one.
All right. Well, I really appreciate everybody showing up today. It's always fantastic for us to be able to speak to our jury pool. I do want you to know that Eric is working feverishly on merch behind the scenes.
Yeah, I got a lot of there's a lot of comments. I do think we'll do I imagine we'll do a show. Today's Wednesday, Thursday or Friday.
Yeah,
and
because
there
I
may
think
be-
Lively's opposition is coming.
there may be some stuff in store. So
Okay. So
teaser.
today's Wednesday. I'm sure we'll be back with you in the next day or two. Thank you so much, Stuart, for all your insight. That's fantastic.
That was fun.
And really appreciate you showing up, jury pool, and we'll see you next time.
Do we have it real quickly? Do we have an update on the charity, or are we? Doing...
Oh, yes.
Oh, that's right. Yep.
So people give us, just as we saw today, people give us donations on the supers and gifts. So once a quarter, we're looking at how much we made on supers and gifts, and we're giving that to charity. But here's the thing.
And JT was wondering, I don't know if we want to keep this close to the vest or anything, but have we figured out what organization? I think we're leaning towards, because we put the poll up and it falls in line with our channel and brand, and people want us to donate to giving legal aid to people in our community. So that's the route we're going towards.
Yeah. So we chose Legal Aid San Diego, but I think that we should keep that open to vote as we're going forward, and we can kind of see how that plays out. But we are going to be giving it to Legal Aid. And the total amount we got on supers and gifts for the first quarter of 2025 is $229.95, which is fantastic. Thank you so much for that.
Appreciate it.
But I was a head scratcher for me, because I'm thinking, I know we've got more than that. I see like what comes in on the screen. And so I researched it. So apparently, if you're watching YouTube on an Apple device and you make a donation like that,
It's a huge cost, huh?
Apple takes 30%.
Ouch.
And then YouTube takes another 30%. And
We love YouTube, though.
What's that?
We love YouTube.
Yes, we
Yeah,
have
nothing-
right.
yeah,
That's
nothing
right.
against-
We love YouTube.
Yes,
and we love Apple.
We
Yeah.
love the gods of YouTube. But they do take their bite.
Yeah.
And so that's how we only ended up with $229.95. So about $230 that we netted for the first quarter. So what Stuart and I wanted to do is match that.
Yeah.
So we're going to double it. We'll put our own money, another $230 against it, $460 for charity. And we'll go ahead and give that to the Legal Aid of San Diego for this first round. And then we'll take stock of where we're at the end of the next quarter and kind of see who else we can help from there.
And can I just, and I'm really happy that we're doing that. I would end this by asking if people would not mind liking and subscribing. We don't normally ask for that. We'll do it at the end when everybody's not watching anymore. Maybe there's just 10 people watching. But if you wouldn't mind liking and subscribing, it helps us because we get our voice out there further. And we're doing this as a hobby, and we're enjoying it thoroughly. And we'll continue to do it as long as people want to listen to us.
Yeah, absolutely.
And if you listen to on the podcast platforms, I'll chime in too. Rate the show on the podcast platforms, Apple and Spotify, because it'll help. I see a lot of people do, which is great, but it helps grow the show. And I have to say it before I forget. Sorry, Donna, for mispronouncing your name.
It's Donna.
It is Donna.
Okay.
It's spelled, yeah. She even said, it's kind of spelled like Dana, but
Yeah.
yeah. So Donna and everyone else, Billy Bush, everyone out there, all the jury pool, we love you guys and hope to collaborate more. And yeah.
But I knew it was Donna, so I want my credit.
Yeah,
for
And
that.
by the way, Jordan says she's running to Spotify. Thank you so much. And I'm assuming Jordan's a she. I hope I got that right. So
Well, thank you, Jordan.
thank you, Jordan.
Yeah. Is there any other business we need to take care of, or
I think we covered the business.
Big donation from Quarter Fate, who is I always see her in our streams and stuff. So we appreciate you.
Holy
Thank you so
smokes,
much.
thank you.
That's great. Thank you so much.
Really appreciate all the support. Well, once again, it's nice to talk to the jury pool, and I'm sure we'll be back with you in the next day or two when more exciting oppositions get filed.
We'll see you in a day or two.
Take care.